Hello, everyone, and good morning. We are in day two of the SCL India Conference 2021 on construction law and arbitration. Yesterday, we had the opening night, which was, of course, a very successful and an amazing open night. In case you've missed it, those delegates who would like to watch it later can go back to the lobby area. And on the left side of the screen, you will see the button sessions. You could go and play and watch that later on. As of now, we are in auditorium number 2, and this is a session on learning from COVID-19's impact on construction contracts and disputes. A session that's very, very important, and I'm sure that each one of us comes across issues dealing with this particular issue day in, day out. And to lead this session, we have our brilliant moderator, Mr. Vyapak Desai, who has very kindly joined us to moderate this session. A couple of announcements before I pass on the mic to Mr. Desai. A few things, which one is that there is also a parallel session happening in auditorium number 1. So the delegates who would like to watch that later on can again go back to the lobby, click the sessions on the left side of the screen and watch that later. So you're not missing anything. That's basically something that you keep in mind. Next, there are a couple of activities that are going on in the lobby area. You could go to the engagement room. There's a quiz that you can participate in. The rules are mentioned, and again, the forum is going to be open. This is something that you can do after the sessions are done. The playback for all these sessions again will be available for you to be able to watch. So those are a couple of announcements, and I will now pass on the baton to the moderator, Mr. Vyapak Desai, who will introduce the panelists for us. Sir?
Thanks a lot, Gracious, and good morning, everyone who has joined today this session. It's a Saturday, and we appreciate you taking time off from your schedule and your weekend, which is obviously very important for all of us. So thanks a lot for joining this conference. I know yesterday was a great opening for SCL India Conference 2021, and I'm sure the next 2 days are going to be equally interesting, and also will give the necessary impetus to the law and development of construction sector, infrastructure and construction sector in India. So thanks a lot, SCL, Ratan Singh, Gracious, and everyone to get this going in the midst of pandemic. So with that, I think today's topic, as was just introduced by Gracious, learning from COVID-19's impact on construction contracts and disputes. I think we all agree in a way that COVID-19 has definitely made either made performance difficult or impossible, right? We have seen the hardships to some parties in performance while rendering others completely incapable of performance. From an Indian law perspective, while we have a lot of people from international participants as well, but at least from an Indian law perspective, impossibility of performance after execution of contract is provided under Section 56 of Indian Contract Act. So if you read Section 56, at least the impossibility part, at a first look, definitely gets covered under Section 56. Question is impossibility equal to force majeure? Is practical or commercial considerations or events which may lead to commercial distress or issues in terms of operation of the contract, or making the contract perform, is that also covered under 56, or for that you need to go back to the general jurisprudence, or maybe the clause as written in the contract? Because If there is no clause, I can understand we can rely on the statutory provision of Section 56. But if there is no provision of force majeure, like situations of COVID-19 and the after effects, then you might have to look at the contract, and then see what is covered and what is not covered, uh, and obviously the other portions of the contract and the dispute resolution clause. So I think impossibility and frustration versus impossibility and force majeure, there are obviously quite a few nuances, and we would today discuss some of those with the the kind of panel we have. We will look into both the Indian aspects, the international aspects. We'll also have view from the real users of those contracts from an in-house perspective, and possibly the most important, we'll also look at it from the perspective of, at the end of the day, who has the right to claim losses or compensation, and how much, right? I think at the end of the day, that's the bottom line of everything we do. It has to make commercial sense. So with that introduction to the topic and the reason why we have taken this topic, while this has been discussed few times earlier in different forums, but we thought it might be a good idea, since now we are almost 18 to 20 months down the pandemic starting, and we are seeing that things are possibly coming back to normalcy, except the recent new variant scare. But except that, I think we are now going to see how parties are going to deal with their contracts and performance, or consequent disputes, considering things are getting back to normal. So with that introduction, let me quickly introduce the panel and then jump on to the topic itself. So we have a very very senior practitioner from India, Mr. Atul Sharma. He's the managing partner of Link Legal. He has more than 40 years experience as a disputes lawyer, and has been involved in a large number of infrastructure disputes on advisory as well as contentious side. Everybody knows you, Mr. Sharma, and your firm doing excellent work on this space. Welcome to the session.
Thank
Uh,
you. Thank you.
we also have Anand Juddoo. Anand is a practicing international charter arbitrator, a registered adjudicator AIAC, and SIAB accredited mediator. He initially qualified as a chartered quantity surveyor and a chartered project manager surveyor. So, again, we'll take his expert advice on the topic today, and particularly on the international perspective, considering his 30 years of experience in construction within building, civil, structural, utilities, mechanical, and M&E environments. Welcome, Anand, on this
Thank
session.
you. Thank you, Vyapak.
Uh, we also have Dr. Manoj Kumar, again, a very, very renowned and well respected name in the Indian legal fraternity. He is a founder and managing partner of a very fine firm, Hammurabi and Solomon Partners. The name possibly would suggest the vision and mission of the firm, and where Mr. Manoj Kumar comes from, and his focus. He is also vice president of Society of Construction Law UK, the SCL India chapter, and also an honorary professor of the Academic Union of Oxford, UK, for business and economy. Very interestingly, he was conferred the prestigious Mahatma Gandhi Samman at the House of Lords, London, and he's a top tier name in construction law, which we obviously know, in addition to conflict management, ADR, natural resources, infra, real estate, corporate M&A, and policy and regulatory. He's an alumni of prestigious Harvard Business School, and a product of one of the best schools in India, National Law School, and obviously he's very very well respected and notable practitioner. in India and globally as well. So again, welcome Mr. Kumar on this session. Uh,
Thank you. Vyapak. Pleasure to be here.
we also have Ranjeet.
Can everybody hear Vyapak?
No,
Apparently not, sir.
no.
We're having some difficulty.
Is it
Vyapak,
better
we are having
now?
some difficulty. We couldn't hear you at all.
Still can't.
Maybe you can try selecting a different mic or the default mic.
Technology, I guess. It lets you down when you need it the most.
So the learning curve is ever growing, is it?
Indeed, indeed.
Discovering. We had a flawless demo the other day, so at least technical
Exactly.
check.
I don't believe that there is a problem with the framework.
Is it
It might just be hardware issue.
is it better now? Hello.
It's much
Yeah,
better
we
now. We
can
can
hear
hear
you.
you. We can
Oh,
hear you
sorry,
now.
sorry for this confusion, and I'm extremely sorry for this. Uh, and I think I hope I was audible till I introduced Ranjit Chouguley.
You
Welcome,
should,
Ranjit, and
Thank
hello.
you. Thank you for having me on board. Not that I could hear, but yes, thank you for having me on board.
you
Oh,
just
I'm so
started
sorry
with
for that.
Ranjeet. So maybe
I'm
you
so
can.
sorry for that. I'm so sorry for that. And then we also have Mrinal Jain, who leads the Secretariat International Economic Damages and Valuation Practice in India, with the focus on quantification of damages, claims, and losses in international arbitration. He is very well recognized in Who's Who Legal's arbitration guides all through last several years, and considered as a thought leader in the Arbitration Expert Witness 2021. He's also a member of SIAC, Users Council, and Society of Construction Law India, Western India chapter. So welcome Rinal on this show as well.
Thank you, Vyapak.
So sorry for the trouble and taking a little more time, but we'll quickly go on to the topic, and let me invite possibly the senior most practitioner today, and having an excellent experience on this issue, Mr. Sharma. If I can introduce you first, and give us a little idea, since we have already have 18 months into pandemic, as to how courts have dealt with force majeure situations like COVID-19, whether it is a force majeure in the first place, and then of course if you can give your perspective on contract management and contractual requirements for such dispute avoidance. Over to you, sir.
Thank you, Vyapak, for your kind words. But the topic, if we look at the impact of uh, pandemic on construction industry, construction contracts, and the project implementation, uh, it is indisputable that the industry has been impacted, and it has been impacted, uh, of course, from the perspective of delay in projects, of cost overruns, and the ability of the industry, which was already reeling under a lot of stress, to and it went down further because of the pandemic. We as lawyers, we always perceived that when the pandemic hit, and in fact, everybody thought that when the pandemic has come, we will have a completely new set of jurisprudence that would evolve around the force majeure concept. As we all know, force majeure is a concept which is not a statutory concept. It took its genesis lies in France, where it is meant to to state a factor which is not within the control of the parties. So, force majeure as a concept is something which is not statutory, at least in the Indian context. Actually, if you see the Indian Contract Act, force majeure is not defined. And therefore, when pandemic happened, we were groping in dark as to what is going to be the consequence of the pandemic, how the industry is going to react. And we believe that we are going to have some, path-breaking jurisprudence that would evolve around the whole concept of force majeure. We had the government taking steps in public contracts. They granted extension of time. But the fact remains, as I said, pandemic or any force majeure condition, because pandemic, if you look at the standard conditions across the world and how force majeure is taken care of in contracts, endemic is something which is already recognized as a force majeure event. So frankly, there was no great difference in pandemic or epidemics. So if epidemic is a force majeure event, pandemic is only an extension of that because it's at a global level. So from the contractual perspective, there was nothing new that emerged which we needed to deal with. But the expectation was, because it has happened for the first time in our lifetime, maybe even the previous generation, we expected something path-breaking coming out of it. But then the legal position, as I said, remained the same, and the whole concept of frustration, which Vyapak talked about, Section 56. Section 56, which is frustration, does not also deal with a force majeure condition, because what 56 deals with is a permanent incapability, and the circumstances which are covered in 55 would have led to the contract being void. So it does not deal with an intervening circumstance, but it deals with a complete incapability or impossibility of performance of the contract. So for frustration, the very foundation of contract has to be impacted. So that is where we find that frustration does not deal with force majeure. Now, obviously, in the context of construction contracts, force majeure would lead to an extension of time in the normal circumstances. And of course, the jury is still out as to whether in the Indian context, force majeure is a change in law situation or it is not. Now, if you look at the whole force majeure implications which evolved after the pandemic, we can put it into two buckets. From a legal perspective, purely from a jurisprudential perspective. The first is that it is a force majeure event per se under the contract. The second is the lockdown, which was necessitated on account of the pandemic, was issued under the Disaster Management Act. So the jury is still out that can you really cover pandemic within the change in law provision, and therefore that could entitle you to some money, but pure contractual implications of a force majeure event will not, in the normal circumstances, entitle you to any additional money. It could entitle you to only an extension of time. So in that background, are we any wiser? Because if you look at the whole jurisprudence, is still relying on Devbrat Ghosh, the 1954 judgment, followed in the Nihati Jute Mills 1968, Anand Vihara 1998, and we only had one or two judgments of the high courts. We didn't have any judgment from the Supreme Court. We had judgments, of course, we had also had them in the Supreme Court way back, Energy Watchdog in 2017. But after the pandemic, we just had stray judgments which did not make any substantial change in the jurisprudence of force majeure, because the law remained the same, and it had to remain the same because force majeure, as I said, is a concept of contract. It is not a concept of statutory implication. So in that background, are we any wiser from a jurisprudential perspective? I don't think so, because there's no new jurisprudence which has evolved on the whole concept and impact of pandemic from the perspective of force majeure, because the law is the same. The second aspect is, are we any wiser from protecting the industry in future? Because whatever the government did was only a stopgap arrangement. They granted extension of time in the public contracts. As I said, jury is still out on whether it's change in law or not. But we did nothing. Precisely, we did nothing to bring in an element of succor to the industry as such. The problems which were pre-pandemic continue to be the same and would continue until and unless we look at two aspects of the construction industry. The first being contract management and how we are managing our contracts, particularly in the public procurement processes. The second aspect is how are we looking at our contract per se? I mean, what are the forms of contract that we are adopting in public procurement? Because public procurement has been the leader in terms of standardization or non-standardization of contracts in the construction industry. Now, what we have been doing, because at least about 30 to 40 years when I started practice, we knew the animal. When it came to public contracts, we knew the PWD contracts or the CPWD contract, and there were a large number of criteria which were codified, and practitioners as well as arbitrators could decide on the basis of those criteria the entitlement of the contractor. But after that, what happened when the PPP came in and we came in with a large amount of infrastructure projects, we came out with bids which were billions of dollars. We tried to adopt FIDIC. We picked up FIDIC silver book and we did violence to it. And violence was of such nature that the entire risk allocation was skewed in favor of the employer, much contrary to the spirit of FIDIC, the pure FIDIC. So what we did was, when we started doing violence to it, we didn't realize that we are going to push the entire industry into an abyss, for the simple reason that in a circumstance like COVID, where you're only getting an extension of time, strictly speaking, and you're not getting any compensation, how do you put the contractor into money? Do you have mechanism within the contracts to ensure that once the cash flows are impacted, how they are going to be dealt with? So this is something which we still need to find a way out. We need to have standardized contracts in the public procurement domain, wherein we send a clear message to the entire industry as to we are going to have this contract, and it will be form the basis of all procurements in future. Every government department is coming out with its own contracts, and that is something which, unless we deal with this problem, we will not be able to sort out, because the problem is the same. The consequence of pandemic is the same as we had previously. So the cause of the distress, so far as pandemic is concerned, was temporary, and if extension of time was granted and there were troubleshooting mechanisms within the contractual regime itself, you could have managed the contracts much more successfully and ensuring. Well, I'm not at all undermining the fact that the pandemic did impact the industry and did impact the progress of the projects. Well, that is a manifestation, but that what became very, very acute considering the pre-existing state of the stressed industry. So I think we need to go to the root of the problem and sort out these contracting issues. The second aspect, which is also very important, is the dispute adjudication, or at least there should be a troubleshooting mechanism within the contract itself, which takes care of cash flow issues during the implementation phase, subject, of course, to a final adjudication. I don't know if a model like UK, the adjudication regime which they have created is going to work. Well, our experience with the tribunalization has not been outstanding, but we certainly need to have certain mechanisms within the contracts themselves which resolve the problems relating to extension of time, the delays, how the risk mitigation takes place. And unless we have that mechanism, the industry will continue to be under stress. So these are some basic issues which we need to sort out before we really start thinking in terms of. It is not the first time that this kind of a situation is being faced. The fact remains that we have faced situations like, if even for example, land acquisition issues. If the land is not acquired, it's as good or as bad as a force majeure condition. But the only question is, you can clearly establish and allocate the breach to the employer. But the fact remains that we have to revisit our entire contractual regime, revisit our contracts, and also revisit our dispute adjudication processes. So these were my opening thoughts. I'll be happy to answer any questions. I have a discussion on what probably other panelists feel and what the participants believe are the issues which are plaguing the industry.
Sure. No, thanks a lot. Thanks a lot, Mr. Sharma, for giving that very, very important and opening, remarks to the whole topic. I think your idea or your suggestion of violence to feeding contracts obviously raises few questions, and I'll come back to you as to what things that we need to really mend going forward. But before that, if I can bring Anand from an international perspective as well, because I think while we have heard what are the problems that we are facing today, and we have not been wiser, as Mr. Sharma says, but how can we be wiser going forward and little more future looking, considering now we at least know what has happened in last 18 months. Anand, if you have any thoughts on your perspective and your experience, and more particularly from a future looking thoughts as to how we should deal with these situations going forward.
Thank you, Vyapak, and thank you to SAL for extending an invitation at this virtual conference. Vyapak, it's Atul mentioned, Mr. Sharma mentioned here, this jury is still out there, and they're still deliberating about whether the pandemic is a force majeure, whether it is frustration, etc., etc. The law is not clear. We have had various countries, especially in France, for example, as far as as far as the public contracts are concerned, whereby they've already declared force majeure. Now, that is as far as time is concerned. But when it comes to money, as Mr. Sharma mentioned, the jury is still out there and there's hardly any jurisprudence available. So we are still waiting formal, I would say, formal decisions from the courts or from jurisprudence which would guide us further. There are a lot of contractually worldwide. There are a lot of issues within the contract, and when we see how much contracts have been butchered, for example, as Mr. Sharma said, the FIDIC has been treated violently. I like that word. We still, it's all in the employer's favor. So we need to actually look at it. Everybody should sort of take a step back and look at things and how do we want those things to be resolved. Now, having said that, I think this coronavirus has been an eye-opener. In fact, it has severely disrupted the economy and with devastating effects on not just the global trade, but also affected industries across the board, especially so in the construction industry. I mean, the construction sector was brought down on its knees. So the impact has been immense when we are fully aware of the contribution of the construction industry to the economy. So right from the beginning, in fact, during the first lockdown globally around 2020, construction sites quickly closed. The employers were laid off, or they were not coming to work for fear of catching COVID, or fearful of catching of being ill. So what happened is that cash flow, and as we know that cash flow is the lifeblood of a construction contract, it became a very severe problem and was a pressing concern more than ever before. So we have all learned of the plight facing the contractors, and it has been fully documented, especially those small and medium contractors, the SMEs in the construction sector. So where do we go from now? We see obviously that this pandemic is still with us, with the Delta variant, and now with this new Omicron variant, we have noted how unstable and jittery governments can be in terms of handling the situation. And in its impact on the construction industry will definitely send heads of the CFOs, CEOs, and whatnot of the construction industry spinning. I will not delve on the aspects of force majeure, which my friend Atul has actually largely touched upon. But I doubt that such claims will be relevant in the present circumstances, especially when we take into account the foreseeability aspects alone. So with this background, it is essential, in fact, to explore an efficient, cheap, a quick resolution dispute mechanism. As Mr. Sharma mentioned, that the UK and certain Commonwealth countries such as Singapore, Hong Kong, Australia, and New Zealand, that have an advantage in that they have statutory adjudication. But for the other countries such as India, Mauritius, Dubai, and etc., the outlook is grim when we want to sort of declare a dispute. In fact, these countries, the most popular method of resolving construction contracts disputes is either adjudication or arbitration. So where no statutory adjudication exists, contractors, especially the small contractors, have to rely on traditional methods of dispute resolution. And we know those can be very lengthy and costly. So what is the object of an adjudication in the where you have got statutory adjudication? Is to reach a fair, rapid, and inexpensive decision upon a dispute arising under a construction contract. But evidence out there in statutory adjudication, parties, especially SMEs, are deterred from using adjudication because of the cost involved and this risk of being ambushed during the course of the proceedings. So there has been a lot of contractors who have actually faced the grunt and taken the bullet, as we call it, and some of them have gone bust because they were unable to pursue the claims in view of the cost being prohibitive. Okay, it's nice being awarded the time, but when we know that cash flow, when it is affected, it can lead to asphyxiation of the financial situation of the contractor. So I think that there's a solution in terms of a contractual mechanism that could be put into place for resolving disputes in a quick, efficient, and cheap manner. We already know that, for example, FIDIC have got like the DAB or the DAB in the 2017 edition. But those schemes are not suitable for disputes for small claims or for small contractors, and is far too onerous money-wise for those contractors to abide. I have in mind a very simple and efficient contractual adjudication disputes resolution mechanism, which may alleviate cash flow and bring like a much needed braver to the SMEs. Certain rules already exist in the industry, but those could be tailored to meet the exigencies of the contracts in hand. In this method, parties should adopt adjudication rules which are streamlined and easy to navigate and to follow without any wasting time and money. So in absence of statutory adjudication, parties should insert or negotiate to insert in their contract a form of interim dispute resolution mechanism, which will provide for adjudication of disputes of, let's say, small value or very simple disputes. Now, we're all aware that these agreements are binding and they are enforceable under the principle of pact sunt servanda. So this mechanism can be really effective when we have a very simple agreement with simple rules for ease of compliance, where the disputes of value, of lesser value, with, let's say, we can put a certain cap on that, and it applies. I think it should be applied to single dispute value only, and it must be raised within 28 days of its occurrence. In terms of the appointment of the adjudicator, the referring party should appoint or should express his disagreement on the adjudication or made by the engineer. So he should refer the dispute to adjudication within 5 days. And in case of disagreement of the appointment of the adjudicator, the parties should be able to refer the appointment to a nominating body, which would be in fact identified in the dispute resolution code. And of course, the nomination body shall be very quick and nominate in turn the adjudicator within the 5 coming days of the party's request for the appointment. And obviously, the adjudicator must enter the reference within 3 days of the date of appointment. So in terms of timeline, I'm looking at a 7 days submission, 7 days for submission of the referral from the date of the notice of the adjudication. In fact, the countdown starts from the date of submission of the referral. The responding party would have 14 days to reply. And if the referrer party wishes to respond to that, he will have a further 7 days. However, the decision should be made within 28 days from the date of referral. And this calendar should include public holidays as well. And in fact, if there is a more complication or complexity during the adjudication process, the adjudicator may make a request for an extension of 14 further days, which may be granted upon the agreement of the referral party. These features should apply to documents-only adjudication, with the adjudicator obviously reserving the right to ask for more written response, further arguments, and counter argument within a very strict time frame. Even if the parties do not comply with those requests, the adjudication should proceed with the decision in absence thereof. The rule should give the power to the adjudicator to open up, review, and revise any certificate, decision, direction, etc., made by the engineer in the course of the dispute resolution mechanism. And of course, this procedure would not be require retaining counsel, very expensive and so on. Obviously, they are free to do so, but it's not essential. Here, the adjudicator should use its own judgment and the expertise based on matters which are already referred in the notice already. The failure to reach or deliver a decision by the adjudicator should entail non-payment of fees which is to be paid to him. And in fact, if any fees have been paid, that should be reimbursed. These adjudicators' fees should be a flat fee or with very minimal percentage. Parties should be able to bear their own cost, and the important of all is that this decision should be implemented within 7 days of the decision, or otherwise enforced through summary proceedings, irrespective whether the contract provides for the parties to challenge it in litigation or arbitration. That is, in short, my views on how to modernize the industry and especially help the small and medium enterprise contractors to bear the brunt of cash flow or lack of cash flow. Over to you, Vyapak, and I'll be available to answer any questions on that aspect. Thank you.
Thanks a lot for this excellent suggestion, and I'm sure the organizers to the conference would possibly record this in seriatim, because this is an excellent suggestion coming out of this session, and possibly the biggest takeaway, to solve some of the problems which Mr. Sharma was also mentioning, earlier. So thanks a lot, Anand, for that. I think let me now bring quickly Ranjeet. Uh, uh, Ranjeet, I think lawyers would love to debate, right? We would always say there are two sides of the coin. This is right, this is wrong. There is an employer, there is an contractor, and we'll always bring in, as many aspects as possible. But from your perspective, what is your take with so much of hands-on experience, right? What is that industry wants? Is what Anand suggesting good enough, or we might have to go back to Mr. Sharma or Mr. Kumar to suggest a better solution, or is this unsolvable problem, so to say? So over to you, Ranjit, if you can give a quick
Sure thing.
5-7 minute snapshot on
Sure
your
thing. I'll try and stick to that time mandate, Vyapak. I understand that we're on a tight timeline, and we really don't want to take away time from everybody else engaging and interacting. And I don't believe that there is anything novel that can actually be said about this topic. In all fairness, this has been debated for the last 18 months, and so there's so much information available on the internet that well, I had plenty to plagiarize from. So, but coming on a more serious note, I think what Mr. Sharma and Mr. Anand have just said has probably upset a lot of people when they're speaking only about time, because I'm pretty sure that there's about 2/3 of the participants in here who are practitioners and who are really hoping for a nugget of gold so that they can take it back to their organizations and somehow create a cost claim. Because yes, the fact remains that this has been something that has been debated amply, but at this point of time, I do genuinely subscribe to the same opinion as my predecessor speakers have said, that this is purely a time event. Now, coming back to what I really want to address, I'm going to stick to three simple compartments, and because I believe I'm exotic as a practitioner, but based on site in a major project which is of national importance, and somebody who is actually an in-house resource, so it slightly have a different perspective. So I think I must touch upon that, primarily if there are some people from the from my line of work or similar in-house counsels who are looking for some validation and some information in context to our area of work. So the first thing that I want to touch upon is, well, what about contract management? Because during the pandemic, because that is what this topic also says. The second is, how did engineers and preliminary adjudications deal with the pandemic? And the third is, well, how do you make it future proof? I mean, what do you do as a practitioner if you're somebody who drafts tenders, or if you're somebody who's actually on field operating as the engineer or as a consultant? How do you take it forward? So future proof contracts, dealing with the pandemic, and contract management. So as far as contract management is concerned, I think the interesting thing was that we moved from a risk management perspective to a crisis management perspective, and boy was it quick. So simply sticking to jotting down risks and grading them and giving them a title simply did not work during the pandemic, because on a daily basis there was immediate escalation, and there were knee-jerk reactions that were coming in from the government, from local authorities, from the people that work for you. So I mean, it was just on many levels, I think we moved from risk management to crisis management, and I think that's really taught us something during this time. So as contract managers and as people who are functioning in the contracts field, we need to look at risk management also, but remember that it could easily convert into a crisis. And while I understand that the pandemic is probably the biblical equivalent of Noah's flood, it's probably a once in a lifetime event, it may not happen again in our lifetimes, but there are certainly lessons to be taken, just so that we as a people have learnings that can then be incorporated in our future laws. Because I mean, what else are laws but codified common sense or collective understanding? So that was the first thing that I wanted to talk about contract management. The next is about insurance policies. Now, a lot of people ought to have been receiving costs courtesy there. Comprehensive all risk policies. If it's called comprehensive all risk, it ought to cover comprehensively everything. But because you shaved off the premium and you decided to cut corners on the premium, you didn't opt for that all important pandemic probably cover. And so therefore, at this point of time, you're left with no gains coming your way. And so I just think going forward, we must cost for actually policies that can alleviate our risk, and a little bit of premium may add to your costs, your input amount, but eventually I believe that it could really have saved us during this time, and that a comprehensive all risk policy, which is mandated in most contracts of public procurement at least, ought to have covered it, but probably hasn't come good. The third thing is, and this is quite interesting, and I think this is from a practitioner's perspective that I'd like to bring out. It's not necessarily a prospect of law, but all progress is related to the economic inputs of land, labor, capital, and so an entrepreneurship. But as far as the labor is concerned, a lot of people are seeing this great exodus so far as the IT industry is concerned. But I'd like to tell you a little bit about the great egress as far as labor is concerned. Currently, more and more labor is feeling disengaged from the work. There is less likelihood of them turning up. Now, as a practical example, Chhat Puja is a time when generally the working force leaves to go back home, if you have working forces from Bihar and those areas. And so they tend to leave. And now what's happened? And what you could generally do is you could up the premium by 20% and they wouldn't leave. If you were to try that now, it doesn't work, because suddenly there is this faith and spirituality that's come back, and people are just looking to God for all the right reasons, I think. But again, it's there's a mindset change. There's a definite difficulty in managing. It's not hysteria now. It's different stages of mindsets that you're dealing with as far as human resources are concerned. So from a contract management perspective, it's quite interesting that these things have happened. The second thing is, and again, Mr. Anand and Mr. Juddoo have already dealt with it, is, what was the pandemic? To force major or not to force major? I mean, that was a big question that went around. And I think initially, a lot of people notified force major, and particularly I'm speaking about FIDIC 1999 contracts. People notified force major, and then probably they went to conferences such as this one and realized, it's probably just a time event. What about my costs? And so immediately everybody went back. I've actually seen instances wherein they have withdrawn force major notification, saying, no, we do not wish for this to be notified under force major. We'd like to go on the change in legislation. And again, like Mr. Sharma mentioned, is that really still applicable? When did the substantive law come in? Were these simply procedural orders that were just working in consonance with the substantive law that already existed from 2005? And so that question remains unanswered. It's probably a gray area, but yes, costs are not being had. And again, like it's been mentioned, whether it was a cost and time event, at this point of time, I have reason to believe it's only been a time event, and costs that cannot be passed on because there's just not enough girth to the provisions that exist. Now, coming to the last part that I want to address insofar as my time is concerned, and this is in context to future-proofing contracts. And I just think that the session says learnings. And so if there is learnings from the field, then I think we can collectively stick them onto paper and then maybe hopefully be better for the next time. So I think from 2008, in 2008, when there was an economic meltdown, which I find is to be the only disruptive activity that I can probably juxtapose the pandemic against. In 2008, when the economic meltdown happened, what happened was immediately people turned towards agile, high functioning, small, compact teams, and everything changed insofar as financing models are concerned. Well, I think now is the time for us to learn, because of what has happened in COVID, because of what has happened during the pandemic, for us to become better. Because for far too long has the same wheel churned insofar as construction practices are concerned, management is concerned. Yes, there is input, there is people are making an effort, project management is getting better all along. But this now is the time, I believe, for disruption. So I think the first thing that we really need to look at is risk allocation. And like Mr. Sharma mentioned, stop butchering it. Let's be fair. I mean, it's so easy for a tender draftsman to completely make an agreement lopsided. I mean, take a standard form of contract and then stick in particular conditions that bring it right back to the old standards that you were originally deflecting from. But if appropriate risk allocation models can be brought in, clear cost entitlement scenarios can be brought in, this I think is very important. Then when there are events, people tend to believe uh, that they've lost out. People tend to believe that there is a cost entitlement, and but if there is no provision for a clear cost entitlement, then people tend to go down the route of disputes. And so just to avoid that, clear cost entitlement scenarios, if they can be brought into contracts, that would be brilliant. And again, right now I think we everybody needs to look at payment terms. We really need to help bring in liquidity into the market. Contractors need help. And so if you're a tender draftsman, stop making back end loaded contracts. Try, and I'm not suggesting a cash and carry model, but I am definitely suggesting that uh, there should be at least mechanisms that can be triggered in the event that an extraordinary event such as the epidemic happens, wherein the leeway is provided for facilitating better payment terms. And last but not the least, and this is again probably in context to practical solutions and working on site, I think now is the time for us to become less dependent on manpower as the resource, and for us to look at ideas such as robotics, look at concepts such as offsite construction, 3D printing, bringing in disruptive technologies that can clearly add value, and just looking at long-term solutions which can be implemented. So I just think I think I've thrown out a lot of ideas and concepts. I'm really hoping that this is bait and we get a couple of bites as far as questions are concerned. So I'll hand it back to you, Mr. Desai, and that's it from my end.
Thanks a lot, Ranjeet, for an excellent balanced view. I think that is what possibly you as a real user of the industry can bring in. So let me quickly bring Mr. Kumar. He's been waiting for his his experience sharing points. And Mr. Kumar, we have heard Mr. Sharma on what are the problems, particularly how we have butchered or violently changed the FIDE contracts. We heard Anand on some of his very specific suggestions to dispute resolution, and of course Ranjit's view on how we can balance these issues. But can we take a little different look at this industry from your perspective? One is, are there any specific suggestions on way forward? Is change in law provision good enough to bring in the aspects of COVID impact from a contract perspective? Are investment claims relevant for the particular discussions? Are they even possible in the situation that we are in? And now the biggest discussion today is mediation, right? We have the Singapore mediation on international, disputes, and if you can bring in, those two or three aspects in, quick, time, that would be very helpful. Thank you.
Thank you so much, Vyapak, and it was quite interesting listening to Atul and thereafter Anand and Ranjeet. And in fact, the three broad baskets that I had planned to speak about is the existing contracts and the fate that the existing contracts went through during the pandemic, the future-ready contracts that we should be looking at, what areas are there to work on, and of course, the very important critical piece is to have a proper dispute resolution architecture which responds in more realistic times. And of course, Atul, Anand, and Ranjeet covered most of these aspects. So I'll try and narrow down on some of my discussions um, on the future ready contracts and what exactly is our learning piece here. If we had had the same discussion in the summer of 2020, possibly some of the nuances may have been still work in progress. And I don't know if the pandemic is behind us as we speak in 2021, and what is still remaining for us to cover as ground, and what kind of discovery still lies ahead for the contractor and employer imbalance that Atul was referring to. And that's the point I would want to start with. I think that's a very important piece to correct in the contract formulation and contract structures between employers and contractors. The imbalance of passing on most of the liabilities and most of the cost burdens onto contractors is something that needs to be corrected. Uh, so therefore, very clearly, the past contracts that we have seen, the standard form contracts, the experience of COVID has shown that they were never they never envisaged this kind of a epidemic, although it was included in the definitions of force majeure. But this scale and this kind of a response, how it would play out for contractors, and therefore what would be the kind of challenges the contractors would face, and what kind of cost compensations the contractors would need. I think they were clearly not envisaged, and the law has not been able to keep pace to give the much needed succor to the contractors. Therefore, the first piece that we need to learn is that all standard forms of contracts need to be revisited. If there are institutional frameworks, the institution should come up with guidelines and addendums to correct the imbalances between the employers and contractors. On more nuanced terms, especially in a tender which is at a fresh tendering stage, I think contractors need to look at the possible implications of pandemic situations much later and factor in the kind of cost burdens that could come on them at the price bidding itself, and negotiate very clearly on how exactly the risks would be allocated in the event of a pandemic playing out at a future point in time. The other challenge which we faced was a very stiff, non-collaborative frameworks of our contracts. In fact, a contract should have the ones that we need to revisit, as Ranjeet was mentioning, to make them future ready. This is a melting point, and this is a time to change. Therefore, the contracts have to be far more collaborative, and in case of a risk scenario arising and dabbling between a risk management and a crisis management situation, the employers and contractors should be in a position to work hand in hand to meet the challenges of cost overruns, extended timelines, etc., and so on and so forth. The other aspect that is very important as a piece to understand, we of course discussed about different jurisdictions responding to force majeure, or also hardship, for example, is looked at differently in different jurisdictions. So this whole concept of choosing an applicable law needs to be revisited little more differently now, and the focus has to be given on what possible challenges could come about in this kind of a difficult scenario. And every applicable law, whenever a choice has been made, should be tested whether there are suitable provisions to balance the scales between all the stakeholders, particularly the employers and the contractors. And if you choose a particular applicable law and if you don't find sufficient, you have to make a choice because of other considerations, but is not very clear on some of these aspects, then clauses have to be built in into that contract at the inception itself. Other issues like financial health of the employer being a ground for suspension of work, lot of negotiation, lot of structural and format changes need to be done. the liabilities of the contractor should be looked at as a limited liability principle, not to pass on every escalation onto the contractors. Be it the issue of, for example, pandemic-driven medical and health-related expenses that a contractor has to incur. Would that pass on as a normal employment, health, and safety expense to be loaded on the contractor, or is it something triggered by the pandemic? And therefore, if it is indeed a situational expense triggered by the pandemic, the contract should have adequate provisions for allocation of such costs amongst the employer and the contractor. Contract management, the structuring of the contract at the very inception itself should have a very clear understanding of at what point what will be the employer's buy-in in terms of sharing the expenses and loads of the contractor. The other piece that I wanted to touch about is the dispute resolution structure that a contract should have. It should be far more realistic, as Atul was mentioning, troubleshooting mechanisms, or as Anand talked about in detail, of a very summary inbuilt dispute resolution mechanism. Either way, whatever is the format that we come around to, it should be capable of responding to resolving disputes or resolving intermediate disputes at a very fast pace, fast track method. We have had some experiences around changes in institutional frameworks around emergency arbitrations. There are questions and challenges, particularly from the Indian context, on enforceability of such awards and the practicability. But then, in a more consensual framework, I think choice of such framework should really help in building a structure within a contract itself. Is a very novel thought, a very forward-looking thought. We'll need to again check on the enforceability aspects, particularly in which jurisdiction are you likely to enforce such a certificate or an award from the person nominated to pass an award there, as well as the entire framework around nominating bodies, because the contract can have a certain set of timelines of 28 days of turnaround time and plus minus 2 weeks thereafter. But the supporting infrastructure around it, in terms of what external support is required, the bodies having sufficient bandwidth and sufficient timelines committed by their panel of arbitrators. So, I mean, with some little bit more homework on this front, I think this can be a game changer, and it should be worth developing it much more. These were broadly some of the thoughts that I had. Investment treaties, of course, that we touched upon initially in a question, Vyapak. I think what we have seen is the government response to pandemic situation has been quite diverse and quite disruptive for quite a few sectors. Construction is also not likely to be left out, in my view, and would sooner or later get affected by the kind of intervening actions of governments or states across the globe, whether it is about suspension of activities, whether it is about acquisition of project assets in the national interest, restrictions on foreign investment strategies, and so on and so forth. We have seen situations where the government has, for example, acquired international airports or acquired projects, and disputes have been threatened and they're likely to play out in times to come. So that will be an area to watch out for, and especially with respect to the commitments that the states breach in the process of responding to these real-time challenges like a pandemic that we've just seen. In my view, pandemic is yet from over, especially the consequences of pandemic on a sector such as construction is yet far from over. And as practitioners, we'll have to wait and watch and supplement our bit as we go forward. That's all from me for now, and I'm of course open for any discussions and questions.
Sure,
Back
sure.
to you,
No,
Vyapak.
thanks a lot for thanks a lot, Manoj, for your very detailed, thoughts on these issues, which have now obviously thrown few questions. We also have couple of questions from the participants already, Raghav, Mudgal, and Jatan Rodrigues. But maybe we'll just wait, Jatan and Raghav, for a few more minutes and get Mrinal first, because I think all these debates are not relevant unless Mrinal tells us, whether you are really going to get anything out of it. I think so. Over to Mrinal without taking any on
Thank
giving
you.
your expert views on how some of these claims can be actually calculated, or even the compensation can be claimed as part of the disputes.
Sure. Thank you. Thank you so much, Vyapak, for that interesting question. And I do have few slides to show some data points. May I request moderator to show these slides? Vyapak, are these slides visible to you?
They are visible, Mrinal. You can go ahead.
Fantastic. Thank you so much, Vyapak and the moderator. So, before we deep dive into the impact of COVID-19 on damages and claims and arbitrations, I think it's important to understand from an economic point of view what exactly is COVID. And I think Ranjeet briefly touched upon the 2008 recession that we faced. Now, historically, when we've had these recessions, they have impacted either the demand side or the supply side of the economies. Unfortunately, COVID 19 was one pandemic which had a simultaneous demand and supply impact. And that was something that really left policymakers and governments all across the globe bewildered. It was a sudden shock, both demand and supply side together. Why supply side? Because there were lockdowns. The governments were facing a dichotomy of whether saving the human life or the economies. And of course, they did make the right decision by announcing those lockdowns. However, that had a repercussion in terms of a supply shock because your raw materials, your food, and everything, a lot of things were suddenly shut. um, when it comes to demand shock, there was a massive shock on the aggregate demand side as well, because the consumer demand, the investor demand also suddenly went down. This statistics that I'm showing you is a shock decomposition for US for the month of March 2020 when the lockdowns were announced. And the red bars as against the blue bars for each sector indicates the ratio of impact of supply versus demand. You can clearly see that for most sectors, the decline in economic activity was majorly due to the supply shock, which is almost 66%, as compared to the demand shock, which is 33%. Why all this is important is when you sit down and calculate sector wise in your arbitration any impact on damages, you need to understand how it is impacting the business. And this is the starting point. Now, of course, while most sectors experienced negative supply shocks and demand shocks, there are some sectors that obviously also had a positive demand shocks. And retail, trade, and information technology sector were two sectors. As you can see, those blue lines that are going above zero, those are the positive impact that we're talking about. Now, with this background, let's see how exactly COVID 19 has affected businesses all across the globe. Um, these are some of the 4 or 5 factors which are relevant when it comes to assessment of damages and claims. The real GDP growth. GDP, or the gross domestic product, is an indicator of whether the economy is growing positively or negatively. As you can see in 2020, based on the IMF World Economic Outlook, these are the actual GDP growth rates, and most of the countries showed a negative GDP growth because of the impact of the pandemic, and the economies are still struggling to come out of it, except for China. With China, the impact happened, and suddenly there was a V-shaped recovery. And it was one of the rare countries that actually had a positive GDP growth in 2020. Here I'm talking about the calendar years. In 2021, as of October, we've seen a massive sort of recoveries in these economies. Um, India, 9.5%, UK, US, both growing phenomenally. But please don't get deceived by these percentages because obviously the base is lower, therefore these percentages appear higher. But a matter of fact is that yes, these economies have recovered because of several reasons, including stimulus that have been introduced by the policymakers in those economy. There have been massive interest rate cuts. There have been obviously the key driver for this economic recovery is the vaccination program all across the world. And that is the reason, the main reason why we see this positive growth. And all this ultimately gets captured in your calculation of damages when you are building different financial scenarios to assume how the business is going to grow in future in your but for scenario, that in the absence of breach, how the business would have grown in 2021 and going forward versus the actual scenario. That difference helps you calculate your loss of profit claims. And this is what is important to understand, that how COVID-19 affected. Similarly, with inflation, especially in an infrastructure construction dispute, we saw inflation being extremely volatile in some of these countries. In a country like India, it actually increased for a few quarters and then it stabilized in 2021. In China, there was a decline in inflation in few quarters, and then now again it's on the way of getting normalized. These changes in inflation, which were extremely volatile, impacted everything from the construction costs to the selling prices that were involved. If it's a real estate matter, everything was impacted because of the change, and which is a direct impact emanating from the COVID-19 or the pandemic. Again, demand side, supply side, you need to segregate the two and then analyze these. Third, your 10-year government bonds yield to maturity. As an economist, I can tell you that the policymakers all across the globe were absolutely shattered. They did not know how to deal with this simultaneous demand and supply shock. The only monetary policy indicator that they could perhaps use was a direct cut in the interest rates. And when I say direct cut in interest rates, it's your yield to maturity on the government bonds. And the reason they do it is because when they announce interest rate cuts, suddenly investment in government bonds becomes less attractive, and therefore investors start flooding and putting their monies in stock market. So that's a direct indicator of how the policymakers can put a stimulus to the stock markets, right? When they are tumbling. And therefore we saw that in several countries across the globe there were sudden cuts that were announced. And I'll just take a deviation here. If you look at this slide, you can see those small circles in March 2020 and in August 2020, for example, for US, the interest rates on the government bonds of US were cut, and it reached as low as 0.4, 0.5%. In UK as well, it reached nearly close to zero. Germany, which was anyways negative when it came to interest rate cuts, it went further negative. And India, when we were in the pre-pandemic stage, hovering around 7%, 6.5% of the interest rates on government bonds or RBI bonds, they were cut down to 5.6, 5.7%. Um, Again, these interest rate cuts have a direct impact when you are calculating your damages and claims. Um, Fourth, consumer confidence index. I've taken an example of India. There are several market research data that's available that will give you this indicator for other countries in the world. What's important to understand is that the consumer confidence index directly gets impacted with this pandemic, with the government policy announcements, with the lockdowns. And as you can see, between March to July 2020, there was a sudden dip in the consumer confidence. Then, when things started opening up, we again had an upward curve. And then we were flat. And again in 2021, there was a sudden dip and then a recovery. This also explains, and Vyapak sir and I were discussing on this a couple of months back, this also explains sort of a W-shaped recovery that is expected during the course of pandemic for an economy like India. Um, Coming on now to another interesting aspect when it comes to arbitrations and assessment of damages, and that is your date of valuation. And the date of assessment is absolutely pertinent because fundamentally, when you calculate damages, you consider factors or information that are known or ascertainable as at the date of assessment. Now, it's mostly a matter for legal consideration where counsels often instruct us that the date of assessment would be the date of breach, date of expropriation, or the date of award. It's a choice that the counsels make based on the legal facts of the matter, but it does have significant economic and financial implications. And I mean, the best case to study for this is Yukos versus Russia, where the difference in the value of compensation on the date of expropriation versus date of award was $44 billion. That was just the delta in the value of compensation between the two dates. The relevant question here is the breach date rule and the exceptions. If you strictly follow the breach date rule, then no impact of hindsight is to be considered. That is, any event that has happened after the date of breach, which was not known or ascertainable as at the date of breach, ideally should not be considered in the assessment of damages. The pertinent question comes if in a construction, or say there's a thermal power plant construction dispute, it's a question of ongoing breach. There are defects in the construction. The first time that you detected the defect is December 19. And if that is the date to assess damages, will you or will you not consider the impact of hindsight, that is COVID-19, if you're calculating your damages as of December 19? The exceptions to the breach date rule, which is again the Golden Victory case, the famous one, suggests that if there are supervening events that are after the date of breach that may materially impact the performance of the contract, such events must be considered. So again, these are some of the nuances that need to be considered when it comes to economic financial impact of COVID in calculating damages. And that's where we take instructions from the councils on how do we proceed and how do we take the impact of hindsight. That's all from my side. Over to you, Vyapak.
View on uh, the impact of COVID and the learnings, including some of the very specific pointers raised by Anand on dispute resolution, and then Manoj also alluded to some of the pointers what we can do. So before we, I have few follow-up questions for our panel members, but before that, I think let's take some questions from the participants because I think they are the biggest users of this conference. So first question is from Jatan Rodrigues, and possibly Mr. Sharma, you touched upon this point. Let me read out the question. What is the debate around COVID's impact? Is it whether it may be considered a change in law under the contract? If so, what's the position of law so far? Has an Indian court rendered a decision related to it? I think you did mention about change of law in your discussions, if I remember right. But do you have any thoughts on Jatan Rodrigues' question?
Yeah, Vyapak, Jatan's question, as Anand also mentioned, the jury is still out so far as this question is concerned. But prima facie, it appears that it could also be, because you see, the question is whether the project came to a halt purely on account of the pandemic, or was it on account of the lockdown, which was in exercise of a statutory power under the Disaster Management Act? Now, uh, of course, the contractors would be leaning towards it being treated as a change in legislation or change in law, because that will entitle them to money. But my personal view is that strictly though it could be a change in law, but then the change in law is caused by the pandemic, and therefore whether it is a force majeure event which has led to the issuance of the notification is something which is very difficult to answer. But I think it could be leaning more towards it not being a change in law. Because the genesis of the notification is the pandemic.
Understood. Anand, do you have any different view than what uh, Mr. Sharma spoke about on this Jatan's question?
Yeah, I still, Atul sir mentioned quite very pertinent points. We are still waiting. I mean, I'm personally involved in a few arbitrations where I am actually where this issue is being debated. We all have obviously our ideas, but the issue is whether the law, the change in law being relied upon by the contractor. For example, the COVID legislation or management of the COVID pandemic, would this be in a way that it would be termed as a change in law, or was it that something which was foreseeable? I mean, that is a debate that's going on. I mean, pandemic. I mean, people are playing on the word pandemic, epidemic, etc., etc. Of course, you will only get time if it is force majeure. But when we're talking about change of law, the nuance is you are trying to get monies involved. But as I stated before, and Atul agrees with me here that the jury is out.
Yeah,
But my
sure.
point is that it may tantamount to a change in law, provided it is wording. One has to assess the wording of the change or the COVID legislation, and see in what way it actually resolves. I mean, let's put it this way: if there's a change in law saying that everybody should stay indoors, now how would the workers be attending the site? So that's
Correct.
something that could be debated. So it's still, I think it's still going on, and I think
Understood.
maybe the next year also will bring
Got
light
it.
to this point.
Got it. Got it. Got it. So I hope that at least gives some light to Jatan on his question. We also have another question from Raghav Mudgal. It says that in a scenario where the contractor would have finished the project before COVID impact, but for the employer's delay, how exactly does this play out in relation to EOT and cost claims by the contractor? Shouldn't the cost that the contractor is suffering because of COVID be the employer's responsibility? Maybe I don't know if I can first go to Manoj and then Ranjeet. If you have any points on EOT aspect of what Raghav is asking, and then of course Mrinal can possibly talk about the cost claims if at all he has any thoughts on that. Over to you, Manoj and Ranjeet.
Sure. So what Raghav is asking at this moment, presumes that the contractor would have been able to complete the project pre-COVID, uh, but for the employer's delay. So possibly a scenario where there are a lot of ifs and buts here. So possibly a scenario where there was a breach by the employer
Correct.
prior to the COVID, and
COVID.
therefore continued into the COVID. So it kind of goes back to what was touched by Mrinal with respect to computation and what the contractor can be entitled to, whether it's to be taken at the certain point in time when the breach happened, or the cascading effect on the losses of the contractor through the COVID should also be captured. And I guess some of it would depend on the language of the contract itself, and of course, failing which the principles that Mrinal explained a short while ago. Maybe
Sure.
Mrinal can also touch on this
Yeah,
and
no, I will
elaborate.
come to I will come to Mrinal on the cost claims, but very quickly we have 5 minutes to go. But very quickly, Ranjit, do you have any thoughts on at least the extension of time claims in the scenario Raghav mentioned, and then Mrinal, if you can come on the cost claims.
Sure, I'll quickly touch upon it, and I think what Dr. Manoj said is very apt. That you have to look at the wordings as so far as the contract is concerned. But yes, if the driving factor for the delay is on account of the actions of the employer, then clearly it would put into a territory wherein everything that flows from it has to be assessed from to the detriment of the employer. Primarily because you brought me into a position where I would not have been facing the pandemic, but now because you have delayed it, say for example, you didn't give me right of access to site. Now these may already be reasons to grant you costs already, and so you may not actually have independent cost claims so far as the force majeure is, pandemic event is concerned. But it, as far as EOT is concerned, absolutely, there's not a doubt in my mind that you would be entitled, primarily because the driving factor is from the employer's default or breach. And insofar as costs are concerned, I would have to lean more on the side of yes, in most likelihoods, you probably would be entitled to some, if not all, of the costs. So yeah, that's my
Got
two
it.
cents.
No, thanks a lot for that. We also have one more question from Mrinal. Mrinal, you seem to be in demand. The question from Rakesh Singh is: are economies moving towards stagflation because of COVID? Maybe you can give a quick 2 minutes on that.
Sure, and we have 3 minutes left, so I'll be very quick. Stagflation is actually a very, very complex economic phenomena, and it's very difficult if economy is going to stagflation for them to come out of it. US faced stagflationary recession way back in 1970s. So stagflation is basically a combination of factors when your GDP growth rate declines, your unemployment increases, and your inflation increases. So all these three factors combined result into stagflation. But this has to happen over a period of 4 to 6 consecutive quarters. You know, the three factors going simultaneously: increase in employment, increase in inflation, and decline in GDP growth rate. Now, fortunately, what has happened is in case of COVID 19, we none of the countries actually entered into stagflation. The reason is because while we saw unemployment increasing, it was for a short period of time during the lockdown situations. Inflation was very volatile. In some countries, it was increasing, in others, it was decreasing. But even that increase was temporary. We saw a couple of months of inflation rising and then sort of again normalizing. GDP growth rate, of course, for the entire 2020 showed an extreme negative trend. But however, towards the end, with the announcement of vaccines, etc., there was a reverse. There was a recovery, either V-shaped, U-shaped, or W-shaped. So the answer to that question is no. The economies fortunately did not move towards stagflation. India fortunately did not move towards stagflation. There was fear about it. There were a lot of debate and discussion around it, but we got saved on that front, and we must consider ourselves extremely fortunate for the same. Thank you. Over to you, Vyapak.
Yeah, thanks a lot, Mrinal, for that quick response on that question. And I know, Mr. Sharma, you had one point to make on the earlier question on the Halliburton's case from Delhi High Court. Maybe if you want to give
Yeah.
one response to that as well, if that helps Jatan's question
No,
or
that
Raghav's.
was in the context of Raghav's question because the issue was whether a delay, which is pre-COVID, could be condoned on the ground of COVID. Delhi High Court has dealt with this in Halliburton, where they have said that pre-COVID breaches cannot be condoned on the ground of COVID. So, I mean, it's a question of fact whether there was a breach pre-COVID, and if so, then it will not, the COVID situation will not come in the way of determining the entitlement of the contractor.
Got it. No, that's very helpful. And with that, I think we are exactly at 11:30. And while we can wait for a few more minutes if there are more questions coming from participants, so please feel free to add those questions. But in the meantime, let me at least congratulate and thank each one of you for such a interesting debate. I think when we started, I remember we a couple of days back, we thought that this topic is discussed time and again, and there is not much to talk about. But I think if you really look back to this session, there has been some very important suggestions, forward looking suggestions made on this topic, particularly on the aspects of contract management, both from Mr. Sharma and Manoj. Anand obviously gave a very detailed and very precise view on the dispute management, which I think should be worked upon. maybe SCL India can take it up as a subject in itself, and produce some paper around it. And of course Ranjit you know gave his perspective to balance both the views, rather than take one view, because that is not helping the cause further. So thanks a lot everyone. Mrinal, again, you gave us a very important perspective on the um, the economic impact, and more importantly how this damages would differ just by changing the date between breach date versus taking into account post facto implications. So I think somewhere some of these topics are yet to be discussed more, possibly rather than less, as the time goes. And thanks a lot everyone for such a great session. Thank you participants for standing it through, asking questions, and I hope you can touch base each of the speakers separately as well in the other sessions and events, including in the lobby, as Gracious was mentioning at the start of the session. So take advantage. You don't get so many experts and lawyers, as we call, for free during these sessions. So I think take full advantage of them, and make sure they give specific answers to your questions. So thanks a lot everyone for joining, and over to you, Gracious and Ruben, back to conclude the session. Thanks a lot.
Yeah,
Thank you.
thank you so much, Vyapak sir, for this brilliant session. And in fact, right in the beginning, when we were, I remember this was maybe 2020 April or May, around that time, we all used to gather for these SCL Western India chapter meetings, and we had started a couple of initiatives regarding the COVID's impact, and we compiled various notifications and circulars. Then we also did a survey, and all of that. I feel like there is a lot much more that we can possibly do, and hopefully we can all put our heads together once again in our SCL Western India chapter meetings and come up with something new, and maybe invite even Ranjeet to come on board and give us in-house experience. So thank you to all the speakers who took the time. I would also welcome all of you and invite all of you to go to the virtual forum as well, now that your session is over, and so that you are able to participate in the other sessions, maybe hang around in the lobby. There are a few activities that you can possibly do. So a couple of things for the delegates who are watching this. There are a few meeting rooms around in case you would like to spend some time over there by network people. That's something you can do. Secondly, there is also a photo booth in the engagement area. So in case you want to post something on social media, please feel free to go there. Click a take a snapshot of yourself with the SCL India branding, and post it online on your social media pages with a hashtag that's mentioned SCL India. Besides that, for for our delegates, the announcements are that the session two will start at 12 at noon, um, and that session will be on allocation of risks in construction contracts. Again, a very important theme. And in auditorium two, that is this auditorium, you will have a workshop happening by Secretariat. Again, Mrinal Jain, who was in this session, will be moderating that. In addition to three of his colleagues from Secretariat. So this workshop is going to be on inevitable issues of time, cost, and damages. So something that you just discussed will certainly outplay in practical terms in the workshop. So look forward to that. That is going to happen from 12 noon to 3:30 p.m. And so these were the announcements for our delegates. Looking forward to seeing you there. Thank you, everybody, and